The members of our Board of Ethics to please introduce themselves before we get started.
Ken Goodnow.
Thank you so much. We usually start with statements from the public on agenda items, but I don't see any here. So, is there anything in Kohala?
Aloha, Chair. I have no testifiers here in Kohala.
All right, thank you, and aloha to you. Okay, then we're going to start with the approval of the regular session minutes of August 7, 2017.
Move to approve.
Okay, is there any discussion in regards to the minutes? Then I call for the question. All in favor of approving the minutes of August 7th, 2017, say aye.
Aye.
Aye. Any opposed? Thank you very much. And we're moving on to new business, except that there is no new business. So we will go right to unfinished business. Petition number 21707, initial review of a petition alleging that a county officer or employee is in violation of Section 2-80, interpretation of Article 2-83, fair treatment, and 2-91, appointing authorities' power to discipline of the Hawaii County Code. Okay, and we have our counsel in regards to that petition. If you could please introduce yourself.
Morning, Madam Chair. Special Deputy Corporation Counsel Gary Murai.
Thank you very much. Do we have anybody that is here in regards to that specific petition?
Madam Chair, I see that the respondent, Ms. Self, is in the gallery. I don't know if you want to ask her to come up to the table or not.
Yes. I wanted to see first if the petitioner was here. Kohala. Our understanding was that they would join us live from Kohala.
Yes, Chair, that was my understanding also, but right to this moment, I see no one here.
Thank you so much. Good Vice Chair. Good
Oh,
night.
a point of information, Madam Chair. My understanding I saw an email that Mr. Heinrich had stated on numerous times he was going to be there, and is that correct? I mean, have we verified that he was going to appear?
That's my understanding as well. Emily, can you please verify if that's correct, that he mentioned multiple times, or that you contacted him and he mentioned multiple times that he was going to be there via a long distance from Kohala?
We sent him a letter on
Can you
August-
put on your, thank you.
We sent him a letter on August 17th notifying him that we were changing or moving his petitions to October. And I included that, I sent it as US mail and via email. He responded on the same day on August 18th that he would be able to make the meeting. And I sent him a reminder email on October 10th, and he replied back on October 13th, also stating that he would be there on the 23rd at 11.
Thank you very much.
Madam Chair,
yes,
sorry,
go
and a
ahead.
point of information again. I am just looking at the minutes from the last meeting, and it looks like we had a motion to continue, a motion to dismiss that was voted on and approved, and so there's a pending motion on the floor to dismiss. Is that correct?
That's my understanding as well, yes.
So, I mean, last time, to err on the side of caution, to give Mr. Highland the ability, to present his case, I think we all, we reluctantly provided that. But if he's not here today, I think he's had notice of the hearing. I'm ready to proceed with the vote and dismiss this matter. I mean, we can discuss the merits. We didn't do that much last time, but I think it was clear from all of us that we really just were continuing to give him an opportunity to be there. It's my thought.
Do we have any other thoughts on this matter? Doug?
I would just ask that if the respondent desires to speak to us, that we give her that opportunity.
I appreciate that. Thank you. Any other discussion from the board? Respondent, if you would like to have any input or say anything in regards to the matter, then ask you to please come up and state your name.
Good morning, Chair. Deputy Corporation Counsel Amy Self. I would urge the commission to dismiss this. This is taking time out of my work. I mean, I was working up to the very last minute. I had to come over here. I have a lot on my plate. And, you know, if this was something that was legitimate, I would understand. But, you know, this is taking a lot of time out of my busy schedule, and I would appreciate it if the commission recognized that it was based on hearsay to begin with, and that it should be dismissed.
Thank you. Could you just please state your name for the record?
Deputy Corporation Counsel Amy Self.
Thank you. Yes, are there any questions to Corporation Counsel at this point in time? Thank you, and I personally can say I totally agree with you. Yes, thank you.
Thank you.
All right, so do we have any further discussion in regards to this agenda item? Mr. Adams? No? Okay, then,
I'd like to, apologize to Ms. Self too, and note that this is the only thing really on our agenda are these petitions, correct?
Yeah.
So, I mean, we're all here too.
Yeah.
Because of that.
Yeah.
So, I mean, I think it's incumbent upon members of the public. I mean, we're here to assist them and serve them, but they need to be mindful of people's time and serious, claims that, well, I'll leave it at that.
yeah. So basically, last time when it was on the agenda already, there was, and we had expected Mr. Highland to be there. We got a notice, not verified necessarily, but a hearsay that he was unable to come due to an accident, and so that's the reason we postponed it. Then we made extra effort to verify and to for him to let us know that he would be here today. Nobody got any information as to the contrary, that something happened and he couldn't be here. And so at this point in time, we have a motion to dismiss. And if there's no further discussion, then I'd like to vote on that motion. Yeah. All right. All in favor of dismissing petition number 2017-07, say aye.
Aye.
Aye. Any opposed? Motion is carried. Going on to petition number 2017-08. We're in a similar situation in that it's the same petitioner.
Correct. Same petitioner, different respondent.
Yeah, who is not here, and therefore, if yeah, go ahead.
Oh, I'm sorry, Madam Chair. I think, though, in this one, maybe we didn't have a pending motion.
Yes.
We just continued it. So I would move to dismiss
All
at
right.
this
So,
time.
do we have a second?
I would second.
Okay, thank you. Same opportunity again. If the respondent would like to say anything, you're more than welcome to come. Seeing that that's not the case, is there any other discussion?
Just, Madam Chair, if I could, in addition to everyone's time here, Mr. Marai flies from Maui, we incur the expenses, he uses up his entire day, it's, that just bothered me.
Yeah, I agree, and maybe perhaps as we're looking at, our guidelines and looking at policies and looking at the code that we need to abide by, that maybe we could look into, the fact that when petitions are made that are already, not really substantive in any way, and when there's ongoing waste really of the taxpayers, not just time but also money, that there could be some kind of a ramification. I'm not too sure if that's even possible, but just to explore that fact, I personally would like to see that. But I'm not too sure if that's something maybe our council can advise us. If
Madam
there's such a
Chair,
thing.
my read of the rules indicate that the board really doesn't have the authority to sanction frivolous filings. I think what, in my opinion, the framework of your rules do allow the board to weed out or screen frivolous complaints at the get-go. The board can find that there can make a finding of good cause and dismiss a complaint, even without giving it a hearing. The board can also dismiss complaints because they don't, they may fail to allege any facts upon which, even if true, would constitute a violation of the code of ethics. So, I guess the thinking is you don't want to discourage people from bringing
Yes.
complaints by, threatening them with sanctions, but there's other mechanisms by which the board may weed out, complaints that may be frivolous or, may have some merit, but simply not cover the subject matter that's within this board's kuleana.
And in those cases, so let's say, if a petitioner brings something to the board that we feel is not, would that be just a decision of the chair? Or is that something that we need to?
My understanding of your rules, Madam Chair, is that that's something that the chair can recommend to the board as a whole. So in other words, when a complaint is received, my understanding of your protocol is that you're usually the first one to see it, and maybe it'll be appropriate for you to go review it with the assigned deputy corp counsel and
Okay.
formulate a recommendation for the board.
And then is it still agendized?
Yes, it would be.
Okay. All right. Thank you. I appreciate it. And then in that case, for example, the respondent wouldn't have to be there when it's discussed.
Well, the respondent could be there. It's just that, that may not be the hearing. In other words, it might be a preliminary matter where the board is deciding to whether to simply dismiss it at that point or give it a hearing. The board can review a complaint and, based on the board's review, find that that there's good cause to simply dismiss it, without having a hearing.
Yeah. And again, I'm thinking of the respondent's time as well, right, to have to come when it is a petition that really doesn't merit us to.
And I don't think we would need to be overly concerned that you're depriving a potential claimant or petitioner of a forum, because it's obvious in these cases that there are other matters, specifically federal court cases that surround this matter.
Yeah.
Madam Chair, if
thank
I
you.
could encourage us to move forward with the vote. We have the opportunity in Agenda Item 7 to continue to have this conversation.
All right, I appreciate it. Thank you. Is there any further discussion in regards to petition number 2017-08? If not, then I call for the question. All in favor of dismissing petition number 2017-08, say aye.
Aye.
Any opposed? So that motion is carried. Thank you. And now we're going into executive session, which means we have to clear the room until we discuss.
Chair?
Yeah.
I would move that we move into executive session where we may anticipate that we might consider the evaluation, dismissal, or discipline of an officer or employee of the County of Hawaii, where considerations of matter affecting privacy would be involved. May also consult with our attorney on questions and issues pertaining to the board's powers, duties, privileges, immunities, and liabilities.
Do I have a second?
Second.
On discussion, all in favor say aye.
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 All right, so we're.
Well, it's okay, that's fine.
Right. I move acceptance of the reviews of the confidential financial disclosure forms as identified by the chair, with the one number that is number 2, I guess, that is being sent back for additional information or review. That's the motion.
Second.
Any further discussion? All in favor say aye.
Aye.
Aye. Any opposed? That motion is carried. And we're moving on to number 7 on our agenda, which is discussion regarding amendments to the rules of practice and procedures of the Board of Ethics of the County of Hawaii.
Madam Chair.
Yes, sir.
I'd like to take the opportunity, depending on whether the members actually have a little bit of time for us to kind of walk through. It would be helpful to be able to go through the rules. And I had an opportunity, once again, to meet with our council in a separate meeting. We threw some things around, actually, that I wanted to bring up to the board for their consideration, so that as we begin to put together a written amended rules, have some idea about how everybody kind of feels about it. So if we could turn to if you happen to have your rules with you. The first thing I would point out is that in the code, you'll notice that the last section is a section that talks about administrative fines. In 2008, the county council passed an ordinance, 808-57, I think it is, that allowed the imposition of administrative fines following formal hearings. Actually, it didn't identify there'd be formal hearings, but in our rules, it would definitely have to be formal hearings. And that would take effect, that particular ordinance would take effect and become part of the code when we redo our rules of practice and procedure. Did a little bit more looking at it. Back in 2009, then Mayor Kanoy actually had prepared a letter and provided it to the board on a number of things that his administration asked the board consider. That never really made it anywhere in terms of any of those suggestions being carried out by the council. Only later, one of those actually came in, and that was the ordinance that took effect back in July of 2016, having to do with contracting. But in there, the letter referred to a couple of the issues. Turns out that we will have to be concerned about when the administrative fine section hits our code. A couple of those have to do with the HRS sections that are referred to, the HRS section 91 and the HRS section, 1 second. Let's see what I do with it. Here it is. 46-1.5, specifically sub 24. And it turns out that those will likely require some type of appellate process. And so the concern is whether or not that's an appellate process, meaning another board or commission at the county level, or some process that allows for the appealing of a final agency decision that would then go to potentially the circuit court. Neither of those options currently exist in statute. And so at least according to the work that the Corporation Council did back in 2009 in preparation of this letter from the mayor's office, that's probably there's some legislative fix that would need to be made before we actually were able to see that particular ordinance go into effect. So as we move forward with this, that's something for us to take into consideration and be concerned about. A second piece of that also is the idea that as we develop our rules of practice or procedure, we'll need to make sure that our formal hearing rules are, in this case, because we will then have the ability to sanction, that they will provide a level of due process that is appropriate for the ability to sanction. Not sure that that currently exists, particularly our rules of evidence, or lack of rules of evidence, as it turns out. So as we move forward, we'll need to, part of the idea is to make sure that the draft rules that will come forward for the board's consideration will include a little bit more stringency, I think, in the formal hearing process, since that's where any sanctions, if they were going to be levied, would come from. Questions on that?
Mr. Adams, if I kind of heard correctly, because of this need for an appellate process, there'll have to be some legislative action on the part of the council before we could, even if we wanted to implement these, higher due process procedures and all that, we still would have to come back to the council taking some sort of action?
I think we'd have to go back to the state legislature.
Or the state legislature?
These are HRS provisions.
So, in reality, it's, while the council has expressed its legislative intent that we should be able to fine, they really have not made it possible.
It's actually.
And they couldn't make it possible because of the state law.
It's a catch-22. It's more than intent. They passed the ordinance.
Right, they did pass
Right.
the ordinance.
And so, but given the crossing of actions with HRS 91 and 46-1.5, where there is this need, see that the ordinance doesn't consider the need for an appellate process,
I see,
right?
right.
91 and 46.1 do.
Right. And well, I don't know if we're not saying that it's a flawed piece of legislation, but
No,
before.
these things happen all the time.
Yeah.
And, so.
So, but really, I don't know as far as our efforts, what we want to do in relation to that. I think all we can do is let the council know you've passed this, but I don't know how
think-
we should proceed.
Well, I think the way we proceed is we'll set up the rules of practice and procedure, which are within our authority to set up, so that we'll assume that that sanctioning authority is valid, and then you then operate according to your county law, your county ordinance, right?
True.
And then at the point where there's a need, if there is ever a need for some type of appellate action because someone who was sanctioned said, I don't agree, or for whatever reason they want to, then typically anything that is a final agency decision based on Chevron goes to the judiciary. So even if it's not included in, so the question then be what the judiciary does with it, but that's kind of outside of our framework.
Well, my only concern is it's like you're setting up a process that we know can be challenged successfully. Because someone's going to say, hey, I didn't have a clear right to appeal. This thing is facially flawed, and I
don't see that we have an option. It's in ordinance. It is part of what the council has said we have. They didn't say you don't get, you have this sanctioning. We need to set our procedures to be able to handle the sanctioning.
So you did talk to Corp Counsel. Do we need a written opinion from them? We could be exposing ourselves to some liability, perhaps. We make our rules that we know really can't be enforced, and we make someone go through all this process, and then it gets thrown out because there was some flaw in the system, and then we've got to pay their fees and costs, the county. Maybe that's, I don't know, it's just food for thought there.
It's food for thought.
But I do agree with you, Mr. Adams, that I think we should follow the highest level of safeguards to ensure due process.
Right.
I agree with you there. We should do
Do that.
certain things anyway.
That's right.
But
Okay. Consider it brought to the attention of the board. The second piece here has to do with something we were just talking about that. It has to do with petitions review. Right, so we did talk about, council and I talked about concerns about how do you manage the ability to review petitions that are coming forward to us. There's been some concern that we have seen, not just recently, but in the past, petitions that might be considered frivolous, for whatever terms those are considered. And we tossed around the idea of, do you have the ability to sanction? Even that term was talked about today. I personally don't see that we have sanctioning authority on the petitions. It's laid out pretty well it seems to me, in the code, who can petition, and as a result, who we have jurisdiction over. The only way we would have any jurisdiction over a petitioner, we would have to try and establish that, and that would be pretty hard, given the charter and the code. Okay? So just so you hear that.
Yeah.
However, we do have within the rules the ability to decide to reject, right? So currently, in our rules 4.5, we have the ability to refuse to entertain a request for an advisory opinion, and then I think also we have that ability in our, I have to go back and check for sure, but I think in our, it doesn't necessarily identify it in the other hearings, the declaratory or the formal hearings. However, I would be inclined to make sure that said ability to refuse or reject a request would not just be associated with Rule 4, it'd be associated with any petition, right? And so in there, it talks about, except in the case of a written request by the elected or appointed officer or employee, former officer or former employee concerned, the board may, for good cause, refuse to entertain a request for an advisory opinion. Without limiting the generality of the foregoing, the board may refuse to entertain a request where, sub 1, the request is speculative or purely hypothetical and does not involve an actual situation. Sub 2, the request is frivolous. Or sub 3, the request does not substantially comply with requirements set out above. And then in no case shall the board entertain a request that is not in writing, not signed by the person making the request or his or her representative. And so we already have within our rules the ability to consider petitions for acceptance or rejection based on these good cause measures. The question then becomes, because it's only the board that can make these determinations, these petitions will show up on our agenda, right? And the concern then becomes, is there a way to try and prevent the use of petitions, particularly, and I'm now drawing up a particular hypothetical situation, particularly where you may have candidates. Candidates find themselves, once they have filed, they find themselves subject to our jurisdiction. And it can be potentially used by whomever to provide, to use petitions as bad publicity, for example. There's no way that I'm aware of right now under our rules where the board has the ability to see these petitions prior to a sunshine law appropriate meeting, right? Now, there are other commissions in other jurisdictions within the state where the staff has the authority to review petitions and not bring them to agendas. That's not my understanding of the staff's authority currently. And we would have to take a look at the code. I don't think it's out of the question for us to ask the staff to be able to do that. If we decided we wanted to provide that authority within our rules. We'd have to take and make sure that the code allows that, but I'm not seeing places in the code that prevents that, which is two different things. So I would ask the board to consider whether or not they would like to see the staff have authority that it currently doesn't have, which is reviewing petitions prior to us receiving them here in a sunshine law agendized meeting and making decisions on whether or not we should see them or not. That's really a question.
Go ahead. Well, I just wanted to mention that, the scenario that you talked about initially with us having to be here and to review whether something has merit. I think for me the issue is, and this is again hypothetical situations that we've already kind of had, where there is a Hawaii County officer employee involved, and therefore our council cannot advise us, and therefore we need to bring a counsel in from another from another island, which is cost to the taxpayer, which would then probably have to be the case, right, in such a situation, because we would want to have counsel that is considered unbiased for all intents and purposes. So I like your second scenario, because for the first scenario, we would be back in that same situation in a way as far as cost is concerned and time is concerned as well. Whereas if the staff would be able to vet some of these, what we would consider frivolous or the speculative types of petitions, then that was something that could be avoided. So I just wanted to kind of point that out.
I mean, maybe there could be some, the only issue with that though is, staff is gonna have to if it's Corp Counsel, then they're gonna have to get Maui Corp Counsel to review it to see if it's frivolous or not, right? I mean,
If they were involved, right.
Yeah,
if it's a county employee.
but it wouldn't have to be
Or-
having to fly
No,
here
just
to do
court
that.
counsel situation. Right,
Just
any
court
county,
counsel.
any county employee
Yeah.
is not that situation.
So, my feeling is, I agree with you, Madam Chair, because, but there should be some protection in place. Perhaps staff could make a recommendation and it be put on executive session saying, hey, we recommended that it not be, I don't know, food for thought. The only thing is, we might never see anything, right? If Corp Counsel gets a petition, I guess it would go through the chair though, maybe, but it might totally go under the radar without a board member actually reviewing anything, which is a little problematic to me, but I think we could compromise and have some system where they review it, and if they're not gonna put it on the agenda, somehow it's communicated to us.
Yeah, or as you had mentioned, that the board chair is
Yeah.
informed, and then if they both agree, then it dies, sort of thing. Whereas if there is a question or an uncertainty, then it would be the chair's purview to put it on the agenda anyway. It could go then into an executive session, questioning, discussion with our counsel in regards to the merit of it, rather than being officially agendized as a petition, right? I mean, that could be an possibility.
Well, and I suppose someone who's aggrieved by your decision, right, could still come to a meeting, even though it's not on the agenda during public testimony, could say, hey, I filed this and it's not being heard, if they wanted to.
I'm not sure that they could currently.
Well,
right?
it's not on the, right.
If it's not on the agenda, I don't know that your
But-
public testimony is
The sun-
allowable.
There is a sunshine law case law. I mean, it's up to the chair to allow it or not, but there is case
Okay.
law that they could talk about anything pretty much,
Okay,
as long as it's,
So far, our practice has been that when there is a statement from the public, that we ask what agenda item they speak to, right? But that could be something that could be added into the rules
Okay.
as well, right?
sure.
Is saying that the public has, because we're talking 3 minutes, so if there is something that the public feels very strongly about, and it's not on our agenda for whatever reason, that they do have that opportunity to, have their 3 minutes of stating their concerns.
Okay. Clearing of the air opportunity.
And given the, if we look at our historic public input, and, I don't think we're gonna have 20 people showing up, type of thing.
Okay, so what I'm hearing is that there is some interest in seeing this vetting. The key is what the procedures would look like, so that we have some kind of middle road. We're not looking at the state commission where the staff has essentially total authority to do whatever they want to do, and then they'll tell the board what they want them to do, as it appears to me. And then, but at the same time, something in between that and where we currently are, which is everything that shows up, we have to look at in open session, essentially.
I myself would much rather
Can you please turn on your mic?
I myself would much rather see council review what's been presented. If it's the feeling that it's frivolous, have that discussion with the chair. If the chair concurs, then not put it on our agenda. Because like in this case of, we just had today with these two, I mean, we could have dealt with that quite a while ago. But we gave it the full effort.
So I would, I feel compelled, a tough word, but I should say that as I am also trying to prepare this, I should let you know that I default to the other side of that spectrum, I think. I tend to see us as an opportunity for folks that don't have any other opportunity to deal with the big bad government situations. And so I get it. It seems like some of this is just reading the paper and being upset and deciding that they're going to roll a petition. And to be honest with you, that's kind of why we're here.
Right.
To be that board that listens to that stuff, at least in my view. Not everybody's view, kind of my view.
I think my sentiments are in agreement with Mr. Adams, but I feel as long as there's some way that we have notice, so it's not secret, then we would be all right. I mean, maybe there's a way where the chair could make initial determination that it's up for dismissal, so the parties don't have to show up, right? I mean, so no county worker is wasting time. That, you know, it's agendized as a certain way. This is for, you know, dismissal by chair or something. You know, then it's out there. But then people don't have to take off work because they know, oh, we're not really going to do anything. And if we change our mind and we vote the chair down and we say, no, we want a hearing, well, then it would be on the next agenda under, you know,
Right.
something. I don't know. I'm open, though, but I do sympathize with your comments, Mr. Adams.
Yeah, I'm certainly very much open to that as well, and I do agree also that, you know, I'm here to serve and, you know, to give people an opportunity to have their concerns heard. So that's not a question at all. I think we're all in you know, agree on that matter. I think it's been, you know, that since I've been on this board, we've had a history, you know, not just once or twice, but a history of, I think that the time of the board, you know, us as members and council, you know, and staff and various other county employees, etc., being, you know, not once or twice, but as I said, multiple times, just wasted our time, and I really I'm a little bit that does concern me, you know. So I do feel that creating a level where we can prevent, to the extent possible, further waste of time and money, because our time is worth some money also, right? You know, and creating a process that would reduce, for sure, hopefully eliminate, but reduce that possibility of wasting our time and wasting our money by petitioners just bringing up things that just really have no merit.
Sure. And that's part of the reason why there are in judiciary rules, counsel, I'm forgetting those things are called again, what? Rules of,
Civil procedure?
thank you, civil procedure. That, you know, you take into consideration the costs associated with doing things when you're talking about frivolous types of, potentially frivolous lawsuit kind of situations. Okay, so,
Don't they provide for vexatious litigants as well?
yep, that's part of it too. Okay. So I hear that, and we'll work with that. A couple of other items, if everyone's okay with continuing.
Yes.
We have a total number of board members of 5. and we have had difficulty, at least over the last 3 years, I think, since I've been on the board, of meeting quorum on occasion. And that isn't necessarily going to be, it doesn't necessarily get any better, even if you are at full 5. All it takes is one to be absent for some reason, and then you can have an issue with, such as we had recently with one who may be, feels that they need to recuse themselves, and all of a sudden you're at a 3 again. If we raise the number of members to, say, 7, I'm not talking about doing it on a district level necessarily, but say you raise it to 7, you think, well, that wouldn't necessarily help, except that if it's this, you may actually improve your ability to not run into the quorum problem. If you had, say, 7 and you're just missing, say you're missing 1 or 2, your numbers still are only 4 at that point, right? Your need to, your voting requirement would be 4, and you can meet that easier than you, with 7 than you can meeting 3 with 5, just because of volume. How do you all feel about suggesting that? It wouldn't, this is not a rules issue. This is something that would probably end up going to the, so I guess this is an initial thought. We haven't had this conversation, but in the process of looking at our quorum issues, if we had a couple more folks that were part of this board, that might help with the ease of moving through petitions.
Logically, that makes sense. However, it's just filling the spots, right? I mean,
Yes, it's always been that.
and that's always been an issue, and so I'm not.
We might make the problem worse because all of a sudden you need a quorum of 4 and you don't have enough to
And
fill
yeah,
it.
we only have 3 willing people, and
Right.
so that's a tough one. It would require, I guess, a charter amendment, right? If it were, or is it just the code of ethics? I'm
I
not
think
sure.
I don't know the answer. Good
Well,
question.
regardless, it would
Yeah.
have to go to the council for them
That's
to
correct.
take to initiate it.
That's
So, I don't know. I think, I would like to hear from,
Charter? Okay.
well, Corp Council or, you're saying the charter? So then it'd have to go to it could be the council or the charter commission, but I'd like to hear from the executive branch as far as what is the problem with filling positions, right? Is it just that they're not doing it, or, I'd like to know more about that before.
Because we all know that this is an exciting place to be. We do God's work here.
Yeah, no, I have to echo that. I think certainly since I've been on the board, the issue hasn't been so much that people that are on the board aren't here. It's that we didn't have people that filled the slots on the board, and therefore we didn't have quorum.
That's right.
And having tried myself unsuccessfully at one point, at least for over a year, to try and work, really, and staff, thank you so much, working extremely hard with the executive office unsuccessfully, to get people to be, and then even then, when people were recommended, it ended up being people with criminal records and all kinds of things. I really agree with you that the issue is really to streamline the executive piece part on how do you excuse me, how do people get onto these commissions? What is the behind the scenes process, and especially making it a consistent thing so that it's not just dependent on the mayor. It shouldn't be just, okay, you have this kind of mayor there for this, and you have that kind of mayor there for that. It should be something that no matter who the mayor is, that there's a specific kind of a process. There should be a job description somewhere within the executive, that says your responsibility is either to advertise it in some way, saying there are positions available, rather than somebody calling somebody or whatever the process may be right now, which, as I said, even trying very hard to push I can say I am not clear on how people are contacted and things like that, and even people that we recommended, not being contacted, et cetera, et cetera. So it's a very nebulous process from where I'm sitting, and so I would rather than looking at expanding the board, try and work with the executive office to create some kind of a procedure, or at least some kind of a process, so that we all know. Okay, and we have the scenario coming up now. We're going to lose one of our favorite members here relatively soon, and I'm already concerned. In terms of how long will it take for a replacement?
Right.
When can we, since we do know exactly when people's term is over, some people can resign earlier, but in general, so far everybody has fulfilled their terms. When we know that already, can we start ahead of time to recruit so that the transition is as smooth as possible and as little time as possible is left open of this transition? So those are the kind of things that I would prefer that we engage in with the executive branch, to see if there's a way that we have a specific person, on that side that we work with, and they know our deadline, they know when this happens, and there's some kind of a clear understanding of how members are quote unquote recruited, or whatever you want to call it, and then approved, etc. Because that's something that I'm currently really not clear about.
That now that there is a request for your social security number, and they do a background check on you, so it could be some people are reluctant. If you have to give your social security number and have a background check done, it's like, oh my gosh, there may be something in their background that they're concerned about. So,
Well, but then maybe they shouldn't be on the ethics council if they have those kind of concerns.
and I'm not
perhaps.
talking about just ethics, I'm talking about all boards and commissions.
Yeah, okay.
Yeah.
Yeah. But okay, that's well noted there. Thank you.
Yeah. How do we feel about, as other boards do, having meetings on the west side also? To me, I think we should be.
It's, for me, it's 6 of one, half dozen of the other.
I mean, we have the ability to have, if you can't make it, you have the ability to come to another location and participate in the meeting, and we are doing it already with our petitioners. I would assume that we would also make that available to respondents. It seems to me that that wouldn't be outside the realm of possibility for board members too.
Go ahead.
The only, and I sympathize, and I understand that, though it would be kind of making an unfunded mandate for the executive to pay for it, right? If we change our rules, I guess they're going to have to accommodate the staff and do that, and that may be something we want to do on principle, but perhaps we should get some input from the executive branch, administration, sorry.
I know in the case of the water board, which I just, spent 5 years on, and we would have 2 meetings in Hilo and 1 meeting in Kona, kind of went back and forth. And since they've built the county building there, it was a little bit easier, with facilities and place to sit. But staff did have to transport all of their equipment to do the recordation, and then all their equipment to come back, so it was a little bit of a problem there. So,
For me, this is on a personal note, strictly personal note. I was quote unquote recruited with the fact that it would be 2 hours in Hilo, as far as serving on the board, and because I take care of my mom, it would be personal hardship for me to have to go somewhere else. But I would, since I agreed to serve, but that's something then that we would have to be very clear on also. All I'm saying is, whoever we ask to be on the board, that's transparent ahead of time. And then I think it's certainly something that I think, certainly from a philosophical perspective, as far as having the other side also have an opportunity to come and voice their concerns and things like that, I can definitely see where the logic of having it, on both sides of the island. I'm just not quite sure if I would be able to, be a case by case basis.
And then finally, for me at least, we'll see some updates because of the technology that we have nowadays, as opposed to what was available in January of 1990, which is where our current rules are at. We'll be making some modifications to the rules that take that into account. We've already talked about that to some degree before. So I appreciate you all being willing to chat about this and, or in the proper parlance, hold discussion on this. And we'll continue to work this and try and get you something that is actually in writing sooner rather than later.
I want to thank you, Mr. Adams, for your work on this, and also council for meeting together and moving the process forward. You know, as you just said, 1990, you know, that's quite a long time ago, and so to update and to, you know, revisit whatever our current rules are, I think is an important process, you know, to stay current in various ways, including technology. So I do appreciate your time and your efforts, and also council and staff to look at amending the rules of practice and procedures. I'm assuming we don't have to have any motion because this is an ongoing process. And then we're moving on to the next agenda item, which is discussion regarding changes to the Board of Ethics monthly meeting schedule. Let me get my calendar out real quick. Our next,
So we've already talked about November 21. We did that last meeting. So if we were, this one would be in
the
regard to
December.
December meeting,
Yeah.
correct? And our standard meeting date would be Wednesday, the 13th
correct.
at 10.
I left my phone in the car.
Probably important, actually. Is
Yeah.
it nearby?
I think it's in my car, actually, I ran and get it.
I had marked in my calendar December the 12th for some reason.
Yeah, I have the 12th right now too.
Oh, that, right, I know of that one,
Okay.
right. So I'm okay with that, it would be though, the next year's schedule. I know the March Campaign Spending Commission had to be changed. I wasn't available at that, but maybe we could do that at the next meeting. I apologize.
So December 12th is what we had decided. We decided that last meeting? Oh, that's
It
just
was
what's on
just
there? Okay.
Well, it was that moving it to the Tuesday part of it.
Okay.
For the remainder of this calendar year was kind of it. So I have it for Tuesday the 12th at 10 o'clock, as always. And if that looks okay for everybody, then we'll keep our next meeting will be the November 21st at 10, and then the following December one will be December 12th at 10 a.m. Council?
So, Madam Chair, you need to suspend the rules, and I think Mr. Adams.
I would move to suspend the rules and move our regularly scheduled meeting scheduled for December 13th, second Wednesday of the month, to the second Tuesday of December, December 12th.
Second.
Any further discussion? All in favor say aye.
Aye.
All right, so we have successfully scheduled for the rest of this calendar year. Oh, that went fast. And I'm checking if there are any other announcements beyond the one that I had already mentioned, that our next monthly meeting is scheduled for November 21st at 10 o'clock right here in the Hawaii County Building. All right, if there are no other announcements, we are adjourning the,
Do we know?
oops, excuse me?
I'm just interested, we have a member of the audience here. Did you have some reason why you wanted to be here, other than being a concerned citizen?
Yeah, I guess so. I'm a believer in women voters and am a ethics committee member, and we're just trying to take up that all of the commission a little closer than the last time.
Cool,
Oh, that's great news.
Yes.
good news, thank you.
Yes.
Thanks.
And I do appreciate the League of Women Voters. They've been very, very active, and we really appreciate your civic responsibilities that you've been taking on. I'm always impressed in the various ways that the League is there to support citizens and to be there to make sure that government works properly. So please give them our thank you.
And if they have any comments about changes to the rules, right, it's a good time to start being involved. So, you can always, anyway, thank you.
All right. I herewith adjourn the meeting of the Board of Ethics, County of Hawaii at 12:10. Thank you. Thank you, everybody.